In today's video, we're going to talk about how to beat debt collector lawsuits and original creditor lawsuits. Surprisingly, we've been very successful helping clients win original creditor lawsuits, and I'm going to talk specifically about the way that we've been able to help our clients accomplish that. Now, I know that if you saw my previous video, debt collectors have bought billions, with a B, billions of dollars worth of charged off debt. And they are suing people nationwide. It is like overwhelming with how many people are contacting us about their cases. And I'm telling you, probably about 75 to 80% of the cases are flawed from the beginning. Like, you can actually get these cases thrown out without having to even have a trial, without just the judge looks at it and say, debt collection attorney, you didn't do your job. This case is dismissed. I'm going to talk about that. Now, but I know because I work directly with clients with these situations, with my staff. I read the emails, I read the live chats. I've talked on the phone with some of you, and people just don't know who to trust. There's a lot of information out there all over YouTube. Don't do this, don't do that. You just want to make the right decision. You want to get all of the information and make the right decision because it's your money. It's your life. And when everything seems to be pointed at you, and that's how these debt collection companies make it feel like, is that you're the only one who owes money. And they're coming after you hard. And you want to get your life back to normal. You don't want them digging into your bank account. You want to protect your money. You're thinking about improving your lifestyle. You're not thinking about going backwards. You want to move forward. You don't want no surprises in your life. I get it. So my job is just to help you become fully aware of what is in front of you so you can get the information and you make your own decision based on your own feelings on what you want to do and from your specific circumstances from your debt collection lawsuit. So now, when you are being sued by a debt collector who has purchased your debt or even sued by the original creditor, you have three choices. And it's funny that some people don't consider choice number one a real choice, but it is a real choice, is that you don't do nothing. And if you don't do anything, you just avoid it, you let them come to your house, they serve you. If it's in your hand, they leave it on the doorstep, or they just take it away and they publish your name on the internet, publish your name in a publication. You think it's all done, or you think that there's nothing else that they could do. Well, the next steps that they're going to take is they're going to motion for a summary judgment, and that summary judgment can last for up to 20 years. And once they get that motion for summary judgment and they get it granted, the next step is they're going to go right back into court to get a writ of garnishment, and they're going to either garnish your bank account, they're either going to garnish your paycheck. And when they garnish your paycheck, they're going to garnish your paycheck every week. It's not going to be like you're paying monthly payments. They're going to garnish your paycheck every pay period. So if you're getting paid weekly, they're going to garnish weekly. If you get paid bi-weekly, they're going to garnish bi-weekly. You get paid monthly, they're going to garnish monthly. And it could be, that could seriously hurt your finances when someone is taking the money that way. So doing nothing will put you into that situation. And I don't know if you watched my recent video where I was on a call like a spy with debt collectors, and they were talking about the new ways that they are collecting debt, especially the debts from business people, but they're also doing this to individual debtors who are not in business. Is that if the debtor has, let's just use, for example, a car. It's all, we all know, hey, they can't come take our car. Our assets are certain assets that they cannot take. This is the strategy that they are using now. Let's just say that you have two cars in your name, and both cars are not paid off. Now, most states, you're only going to be able to, if someone wants to take an asset, they're going to be able to take one of those cars. I mean, that's just the rule. Normally, everybody was like, it has to be paid off because why, I got to pay payments to the lender. The strategy that they're doing now is they'll evaluate the asset and then they'll go and pay off the asset. So they'll get a ruling, get an order from the judge to take the asset. They pay off the asset. That's what uncovers the asset. And then they resell the asset. And these guys were so devious. They were like, if we'll just keep taking assets to get to the amount of money. They're not trying to make all the money on one asset that they take. They're trying to just let it add up so they'll get this asset. That's why they were doing it really big with business people, is that they were just going, hey, we'll take this asset and we'll take that asset and then that one. Anything that they could take to add up to be the amount that they're going to take. So that they were like bragging, hey, we got $5,000 from that one, 5 from that one. And then check this out. Here's another strategy that they're using. And so remember, I'm making you aware of this stuff. I'm like taking time to go and find this information so I can help you. So I hope you appreciate it. Like this video right now because I hope you appreciate it. Here's the other strategy for people who hire an attorney to represent them against a debt collector that might be trying to sue them. If you give that attorney a retainer, they were talking about like a retainer was given to an attorney. A lot of people don't know this. A retainer does not mean that your money is like 100% used. It just means that the attorney didn't trust you and they were like, hey, you need to put some money up so I can take away, I'll give you a receipt of the billable hours, but I don't, you're in trouble right now, so I want you to put some money up, and then I'll take away from that, and then when it gets short again, I'll come and you can re-up it. They were taking the retainer money away because that retainer money is still technically the debtor's money. So they had actually went to the attorney and said, hey, we have this we have this judgment order from a judge. We know that you got a retainer for $5,000. How much did you use of it? The attorney said they only used a couple of $100 of it. They said you got to give the other $4,800 to us. That's exactly what happened. That's exactly what happened. So we need to be aware of what they're doing. Like just because a debt collector's in the debt collection business and they have the CFPB rules and all of that stuff, yes, but humans, we are creative. We are creative, and we're always looking for some way to do something either easier or some loophole to get around on something. And so that's what these debt collectors are doing. They have bought billions of dollars worth of debt. I'm pretty sure when 2024 ends, the debt collection industry is probably going to have double the amount of profits that they had in 2023, and the regulations are even tougher against them. And the reasons why is, which I'm going to talk about in a minute, is because people don't know what I'm about to tell you about how you can beat a debt collection lawsuit. And it doesn't matter if it's from the original creditor or a debt collector. Now, choice number 2 is you can settle the debt so you can move on with your life. And that is a legitimate decision to make, especially if you evaluate, number one, how you feel about, do you want to even fight the case? Like sometimes people will come down and they'll be like, what should I do? It's not about what we think you should do. What it's about is what you are willing to do. Because if you're going to go to court and fight, you either going to have to fight for yourself or have an attorney there fighting for you. And so that's a decision that you got to make on what you want to do. But let's just say that you want to fight for yourself. You don't want to add to the expense. You want to at least see what you can be able to do. And that's where we come in and we're able to get you the documentation so you can, get that accomplished and have the best chance of winning. But option number 2 is settle the debt. You can settle the debt for less. But you have to get them into the mindset of it, because if you just jump in, hey, we want to settle, and unless they come and offer it, but if you just jump at it, they're gonna sometimes think that you're hiding something, and it could even make them come after you harder. We've even seen where clients had to come to us because the debt collection attorney or representative, they never did get to speak to the attorney. They were like, we want 100% of it plus the fees. And I was like, that's crazy, but you have to work them down to do it. And some of the times you're going to have to get someone to speak on your behalf to kind of extend it out, and then get to the attorney that is actually managing the account and get them to understand that we need to come to some type of agreement so everybody can move forward. Some of the times they have to wait. If they are hired by the original creditor, they have to get that permission from the original creditor to make certain settlements. The original creditors give them a certain amount that they could just say, hey, if you get this amount, you can settle. But some of the times, if you want to go lower, which most people want to go lower, there's going to be some things that you're going to have to do. Sometimes it's going to have to deal with financials. We don't like getting our clients into having to provide financials. We try to go back and forth to keep the financials out of it so they stay out of your business. Because just think, they see your bank account, they see all that stuff, they'd be like, hey, we got everything. If we don't come to an agreement, we just go dip it to the bank account or do what we're going to do. So you have to be very careful in that negotiation process. As a matter of fact, if you're handling this stuff yourself, you need to have a very good feeling that the deal is going to go through before you hand over financials. Now, if they do request financials, let's just say that you have a judgment and they request financials, you got to give those financials, or you could be in contempt and they can have a warrant out for your arrest. So if you end up settling, that you get the move on, you can work on getting, number one, they're going to dismiss the case, make sure that they dismiss it, and then you can work on getting your credit taken care of after that. The next thing is if you want to fight, and there are some people who are just like, I just want to fight. Even if it's with the original creditor, we have people who just say they want to fight. And I think that comes about from people becoming aware of different. Number one, that our court is about presenting evidence. Number one, like, we know that there's been people who have, been convicted. I don't want to bring this into that type of stuff, but there are people who have had things happen to them and they did not do it. And you were like, how can this happen? And then you've seen the flip side where people did something and then nothing happened to them. And you're like, how can that happen? And it's because what has happened is that either that attorney or that an individual made the whole case about the process of the case. And so the first thing that I want to talk about, which we have actually started paying more attention to, because when we've reviewed documents from individuals, we were like, this stuff is just screwed up from the get-go. Like, how could they even bring this case? And the reason why they can bring the case, I answered my own question, is because people were not aware of how they have to bring a case. Everybody's just focused on the amount, who the original creditor is, who the debt collector is, that's trying to come after them, that they had the account, all of that stuff. But they never thought about the process of the case itself. The case itself. So the first thing that you can look at is the case itself. I call it the presentation of the case itself could be flawed from the beginning. Can be straight from the beginning, could be flawed. And when that happens, you can motion for a judgment. And I know that sounds crazy, but this is where you can motion to have the case withdrawn, dismissed, without a trial, without anything, because there's flawed pieces of them even presenting the case. And that takes work, though. That takes work. And I've just given it to you. It takes work. You're going to have to look at your documents, and then you're going to have to look at the laws, and you got to see, did they present the case the right way? A lot of people get stuck on, did they serve me, I didn't get served, this and that. That's a piece of it, and varies from state to state. But the documentation, the presentation of the case itself, if there is a flaw with that, the case will get dismissed by the judge without having to go to any trial. The next step is if it passes the test of the presentation, then the next thing is that you got to start building your case. Number one, you got to counter and you got to counter their evidence against what you believe they should either have presented, or the lack of documentation, issues with your privacy, issues with complete accounting, issues with the complete account number, issues with, did the debt collector do their job, the debt collection attorney that's working either for the original creditor or for the debt collection firm, did they do their job according to what they're supposed to do with the CFPB and the Fair Debt Collections Practices Act? Did they follow their document process for what they presented in the case? If so, it can make it past the first stage, but now we're getting into where we're going to build your affirmative defense against what they've presented against you, for technically the facts of the case that in their eyes of what they're presenting to you. And that's how you're going to be able to overcome that. Now, it is different for every case. I've even seen it to where the same attorney, because they'll use paralegals within their office, the same attorney would have the case presented a different way. And I think that that's because the paralegal that was putting everything together for them did it different than the other paralegal that they might have in their office. Some of the times it's the same. If it's the same and it's been flawed, it's going to be flawed moving forward all the time. So what I want to offer to you is, if you're being sued by a debt collector, you need to go to my website, thecreditrepairshop.com. In the live chat, I want you to immediately upload your summons for review. Put your phone number in there too. We will call you back, let you know what we see, let you know the options, but also we're going to ask you how you feel. If you're just more the mode of not wanting to go to court, not wanting to deal with this, then there's nothing wrong. We can help you with a settlement, or you can move forward and work to get the settlement yourself. But we'll review your documents and we will follow back up with you and let you know your options based off of what we've seen. All right, so go to the website, thecreditrepairshop.com, and you'll see the pop-up for the live chat. Click that, submit your information with your phone number, and upload those documents for review. We'll let you know how we can help you. If you need help with your credit, please visit thecreditrepairshop.com. and you can see everything about our services. Due to the recent TSR, telemarketing service rule, we are not allowed to talk to you. I know this might sound crazy. We are not allowed to talk to people until they become clients. To become a client of the Credit Repair Shop, you pay zero. And I'm also going to get this book to you, and you pay zero. Let's get that Credit Secrets book to you. You pay zero. I'm going to pay the shipping, so you pay nothing. But you do have to follow some steps. You got to get signed up. We have just one plan now. We made it very easy, one plan, and it's a month-to-month service. So we provide service, you pay. We provide service, you pay. You can cancel at any time when you feel that your credit is where you need it to be. So it's not like a forever type deal. And so you have to sign up for the service, pay zero, and then you got to sign your credit services agreement. This is a requirement. Once you do that, we can talk on the phone, buddy up, do your review. You'll have customer service can call you live, all of that stuff. It's actually made it easier. And actually, one of the things that I really like about it is that when you go to my website, you get to read, see what we can do. It'll help you pay more attention to what we do. So if there's any dispute, you'd be like, well, it was said right here on the website. We'll go right there to the website, be like, hey, okay, we need to tighten up the way that that's explained. So it's going to help everybody understand it. The sales pitch, quote unquote sales pitch, is said the same way all the time because you're reading it from the website. If you decide to sign up, you're deciding on your own. There's no push, there's no hard sell, None of that stuff. So go to the website, thecreditrepairshop.com, and click on getting started. We'd love to help you repair your credit, increase your scores. If you need your credit reports and scores, go to the website, your3scores.com, to grab your TransUnion, Equifax, and Experian credit reports and all 3 scores. That is like the gasoline for credit repair, because you gotta know what number one, what's going on, and number 2, the results. The results are given that way now. They don't really mail out too many results. And then if you have debt collectors coming after you, you can stop a lot of this stuff early if you respond to them the appropriate way. First way is if the debt is past the legal statute of limitations. I'm going to give you that letter. Because if the debt is past legal statute of limitations, they cannot collect on that debt. There's no need for a debt validation. You just need to follow my steps on notifying them about the debt being past legal statute of limitations, and that you have no legal they don't have a legal option on making you pay the debt. It's only a moral obligation, and it's okay if you have a moral obligation. You can work out a deal to pay them. And the other 2 letters is a debt validation letter and a cease and desist collection activities letter. Usually the cease and desist collection activities letter can stop a debt collector from coming after you, because you're going to ask for certain information in that first letter. And then if they do try to continue coming after you, use the debt validation letter to get more specific about what they're going to need to provide to you in that debt validation. And if they disregard that and then they try to take you to court, that could be used as evidence that they didn't follow the Fair Debt Collections Practices Act. All right, this is Stephen A. Williams, president and founder of thecreditrepairshop.com. Like this video, share this video, post your questions and comments. Thank you for your time. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.